Ever stop to think about what happens when a country, well, changes? Borders move, nations break apart, new ones emerge.
Hmm.
It happens more often than you might think, and it really throws a giant wrench into, international agreements.
Absolutely.
Yeah.
What happens to all those treaties, all those obligations? It's a
Yeah.
fascinating legal puzzle.
And often surprisingly messy, I imagine.
It can be. And that's exactly what we're digging into today, state succession in international law.
Right. Specifically, how these huge changes in who a state is affect that whole complex web of treaties.
Exactly.
And for you listening in, if you want to get smart on these big topics without getting lost in the legal jargon, well, you're in the right place.
Definitely. We've done the groundwork to pull out the key ideas on this pretty tricky subject.
We're drawing on some solid sources today. There's work from Professor Yarek Krivoy, that was 2017.
From the British Institute of International Comparative Law, and a really thorough 2013 piece by Patrick Dunbarry and Daniel Turp.
We'll also bring in some perspectives from Matthew C.R. Craven's work back in '98 and a 2012 paper from Legal Response International about unilateral declarations.
Wide range.
So the mission today. Let's unpack the main principles, the big debates around state succession, especially where it bumps up against international investment law.
Yeah, we want to clarify the different ways people look at this and what it all means practically.
Okay, so first things first. What exactly is succession of states?
Right.
Is there a standard definition?
There is. The most common one comes from the 1978 Vienna Convention on Succession of States in Respect of Treaties.
Okay.
It defines it as, and I'm paraphrasing slightly, the replacement of one state by another in the responsibility for the international relations of territory.
Simple enough on the surface.
Right. But as Professor Krivoy points out, everyone agrees it's actually, highly technical, complex, and often pretty controversial.
I can see why. High stakes. And I gather there are two main schools of thought on what happens to treaties when a new state appears.
That's right. Two dominant approaches. The first one is often called the clean slate doctrine, or tabula rasa.
Tabula rasa. Okay. Blank slate.
Pretty much. It means new states don't automatically inherit the treaties signed by the state they came from.
So they start completely fresh, treaty-wise.
Uh-huh. And Professor Krivoy notes that in actual practice, this clean slate approach has largely been the dominant one, despite what some conventions suggest.
Interesting. So practice goes one way, maybe theory or aspiration goes another. Because there is another idea, right?
Yes, the principle of continuity. This argues the opposite. New states do automatically succeed to the treaties of their predecessor state.
Okay, so they inherit the whole package.
That's the idea. And what's really interesting is that the 1978 Vienna Convention, the one with the definition, actually leaned towards this continuity principle.
But states didn't really follow it.
Largely, no. As Krivoy highlights, state practice hasn't really lined up with the convention on this point. Limited success, you could say.
Why do you think that gap exists? Why prefer the clean slate in reality?
Well, it's that classic tension, isn't it? Between what international law aims for, stability maybe, and the realities of state sovereignty.
Ah, sovereignty. A new state wants to choose its own path.
Exactly. The clean slate offers more flexibility, lets them decide their own commitments, even if it creates, uncertainty for others.
Makes sense. Now, there was this other concept mentioned, moving treaty frontiers? What's that about? Sounds like treaties expanding.
That's basically it. The idea is that when territory is transferred and becomes part of an existing state, the treaties of that receiving state automatically extend to cover the newly acquired territory.
Got it. So the treaty follows the flag, so to speak.
Kind of. A key case here is Sandham Investments Limited v. Lao People's Democratic Republic.
Yeah.
The Singapore Court of Appeal looked at whether a China-Laos investment treaty would apply to Macau after Portugal handed it over to China. Their starting point was, yes, it would apply, unless there was some specific exception. The treaty frontier moved to include Macau.
Okay, so treaties can move with territory. But going back to the clean slate idea, are there times when it definitely doesn't apply? Exceptions.
Yes, definitely. There are recognized exceptions where continuity is generally accepted.
Like what?
First, treaties that basically just write down fundamental rules of general international law. Think things like the Convention on the High Seas or the one on the continental shelf.
Rules everyone's expected to follow anyway.
Exactly. They reflect widely accepted norms, like the prohibition of genocide, so they bind states regardless. Second, you have what are called objective regimes.
Objective regimes.
Yeah, these are treaties tied to a specific territory itself. like rights to use a waterway or a demilitarized zone or specific fishing rights. Their purpose is linked to the place, not just the government.
So they stick with the land.
Right. Boundary treaties are another classic example. They generally continue. And finally, there's a mechanism in the 1978 Vienna Convention for certain multilateral treaties.
What's that?
It allows what they call newly independent states to opt into some existing multilateral treaties relatively easily through a notification of succession. So a sort of simplified joining process.
Okay, that makes sense. Some things are just too fundamental or too geographically fixed to just wipe away. What about the regular two-country deals, bilateral treaties? How does succession work there?
That gets a bit more complex. Professor Cravoy points out two main ways tribunals tend to approach this. One is focusing really tightly on the specific deal between the original two countries.
So looking at that treaty, those parties?
Yes. What did they
What's
intend?
that?
How did they behave later on? Especially in any legal fights about it. It's about their specific relationship.
Less about a general rule, more about the specific case.
Exactly. And a really good illustration is the Worldwide Minerals v. Kazakhstan case.
Okay, what happened there?
It involved a Canadian company claiming Kazakhstan essentially bankrupted their uranium processing operation back in the mid-90s.
Mm.
The crucial legal question was, did an old investment treaty between Canada and the USSR still apply between Canada and the newly independent Kazakhstan?
Wow, yeah, that's a puzzle. Did it?
Well, the arbitration tribunal dug into the evidence and actually said yes. It looked like both Canada and Kazakhstan intended for that old USSR-Canada treaty to continue.
Really? What evidence did they have?
Several things. There were official statements from both sides suggesting they meant for it to continue. There was a 1997 free trade agreement they signed, which actually mentioned the older investment treaty.
Ah, so they referenced it.
And also the 1991 Declaration of Alma-Ata. That's where Kazakhstan and other former Soviet republics basically signaled they'd try to honor the treaty commitments made by the USSR.
So putting those pieces together, the actions and statements suggested the old treaty lived on even without a formal new one, just like it.
Precisely. It shows the power of conduct and implied consent.
That's a really important point for anyone operating internationally.
Absolutely. And Cravoy notes this could mean investors from, say, other former Soviet states might try to use these old USSR-era treaties against the new CIS countries. It highlights the lasting shadow of past agreements.
Fascinating stuff. Okay, we've talked about state-to-state agreements. What about the rights of, ordinary people or companies caught up in these changes?
That brings us to something called the theory of acquired rights.
Acquired rights.
Yeah, the basic idea is that a change in sovereignty, a new government taking over, shouldn't just wipe out the existing private rights of foreign nationals.
So things like property ownership or investments.
Exactly. The successor state is generally expected to respect those rights or at least meet minimum standards of international law and how it treats them. It's kind of safeguard.
A vital protection, I'd imagine. Okay, let's shift gears to something more dramatic. Armed conflict. What happens to treaties when states are at war? Does everything just stop?
That's another complex area. There's a set of articles, the articles on the effects of armed conflict on treaties, ARIC, for short, adopted by the UN General Assembly in 2011.
ARAC, okay. What do they say?
The general principle, Article 2, is actually that armed conflict doesn't automatically terminate or suspend treaties, not even between a state at war and a neutral one.
Huh. That feels a bit counterintuitive. You'd think war puts everything on hold.
It might for some treaties, depending on the circumstances and the treaty itself, but the default is an automatic termination. War doesn't just erase all legal links.
Any examples?
Well, Professor Krivoy mentions the Russia-Ukraine bilateral investment treaty. Apparently, it even has a specific clause.
Oh, yeah.
It says that for investments made before the treaty ends, its protections actually continue for 10 more years after termination.
Wow. That's planning ahead, even anticipating conflict, maybe?
It shows a recognition that these economic relationships and the legal frameworks around them can have effects that outlast the treaty itself, even through conflict.
Okay. What about a slightly different situation? Military occupation. Not annexation, just occupation. Does state succession apply then? Do the occupiers' treaties suddenly apply to the occupied territory?
No, generally not. Article 40 of the Vienna Convention on Successions specifically says state succession rules don't apply to military occupation.
Why not?
Well, remember, Article 6 of that same convention says it only applies to successions that happen in conformity with international law.
And military occupation usually isn't.
Exactly. It's generally seen as unlawful, so it doesn't trigger the normal rules of treaty succession. You can't legally inherit obligations through an illegal act.
Makes sense. So what does govern the occupier's responsibilities then?
In that case, the occupying power is bound by the specific laws of belligerent occupation and also international human rights law and international humanitarian law. Different rules apply.
Right. And building on that idea of unlawful acts, there's something about not benefiting aggressors.
Yes, that's an Area C2, Article 15. It's the prohibition of benefit to an aggressor state.
Okay, what does that mean?
It means a state that commits aggression, that starts an armed conflict unlawfully, cannot then use that conflict as an excuse to terminate or suspend a treaty if doing so would actually benefit them, the aggressor.
So you can't start a war and then say, oh, because of this war I started, I don't have to follow this inconvenient treaty anymore.
Basically, yes.
Yeah.
You can't profit legally from your own wrongdoing in that way. Professor Krevoy notes, for example, that Russia hasn't been participating in some relevant international proceedings related to these kinds of issues.
Interesting. Okay, let's think about how states change. Sometimes it's secession, a part breaks away. Other times a whole country dissolves. Does that difference matter for treaties?
According to Dunbury and Terp's analysis, it historically seems to have mattered, yes.
How so?
Well, they point out that while the 1978 Vienna Convention tried to push for continuity, regardless of how the state changed, actual state practice, especially before that convention.
Like what example?
Cases like Pakistan separating from India, Singapore from Malaysia, Bangladesh from Pakistan. In those instances, which were often seen as secession, the new state frequently adopted the tabula rasa, the clean slate approach.
So secession often led to starting fresh with treaties, historically speaking, more so than maybe a complete dissolution.
That seems to be the trend Dunbury and Terp observed in state practice. But, and this is a big but,
Go on.
Matthew Craven's work really highlights how difficult it is to even neatly categorize these events. Is it secession? Dissolution? Absorption? Often the lines are really blurred.
It's not always clear-cut in the real world.
Not at all. And that ambiguity makes applying any rigid legal doctrine like secession always means clean slate really challenging. Craven emphasizes the huge variety in state transformations and the lack of one single agreed-upon theory to explain it all.
So the legal frameworks struggle to keep up with the messy reality of politics and history.
You could definitely say that. Craven discusses how the classic debate, universal succession versus clean slate, just doesn't capture all the nuances. Neither extreme works perfectly in every situation.
The big theories have limits.
They do. Which leads to another perspective Craven explores, from a scholar named O'Connell.
Okay, what was O'Connell's idea?
He suggested maybe we focus too much on the abstract personality of the state, whether it's legally the same entity or not.
Instead of that.
Instead, O'Connell argued we should look more at the actual continuity of legal relationships and the degree of political, economic, and social disruption caused by the change.
More practical, less theoretical.
Sort of. He even suggested maybe going back to an older 18th century approach,
Which was?
a kind of presumption in favor of continuity,
Yeah.
unless a concrete analysis of the specific situation shows a good reason why the obligations shouldn't continue.
That's a really interesting shift. Focus on the practical impact, but does the state's actual identity still play any role?
Craven argues it does, yeah, beyond just the formal legal criteria for statehood.
In what way?
He suggests understanding a state's sense of self, its uniqueness, its community identity, that this is important for deciding the legitimacy of inheriting old obligations. Is it fair, given who this new entity is?
So there's almost a moral or political dimension alongside the purely legal one. Who the state perceives itself to be matters.
That seems to be Craven's point. It's more than just legal boxes to tick.
Fascinating. Okay, one last piece we mentioned earlier. Unilateral declarations. Where do they fit in when states change?
Right, the Legal Response International paper talks about these. A binding unilateral declaration is basically when a state makes a public statement intending to create a legal obligation for itself without needing anyone else to agree.
Like making a promise to the world.
Kind of. Classic examples are Egypt's declaration about operating the Suez Canal or France's statements about stopping atmospheric nuclear tests. The International Court of Justice said those were legally binding on France.
Just based on the statement itself.
Yes. Provided the state clearly intended to be bound, the statement was specific, and the person making it had the authority, usually head of state, head of government, foreign minister.
Okay, so how does that connect to state succession? If the old state made such a promise, is the new state bound?
That's the question. The continuity of that kind of self-imposed obligation would likely be analyzed using the same sorts of principles we've been discussing for treaties.
So, looking at the nature of the obligation, maybe the circumstances of the succession, the identity questions we just talked about.
Exactly. It gets folded into the broader, complex assessment of which legal relationships continue and which don't after a state transforms.
Wow, it really underscores just how intricate this whole area is. No simple answers.
Definitely not. State succession is constantly evolving, very multifaceted.
And it really feels like it boils down to this fundamental tension, doesn't it?
Between what?
Between the need for some stability and predictability in the world, knowing which rules apply, and the right of new states to, determine their own future, their own sovereignty.
That's a perfect way to put it. That's the core tension.
But understanding these underlying principles, the different ways of thinking about it, clean slate, continuity, the focus on identity, it gives you a valuable framework, right?
Absolutely. It provides a lens to analyze what's happening now and what might happen as the global map continues to shift.
So, a final thought for you, the listener, to chew on. As we see more and more complex state changes around the world, how might these ideas about state succession need to evolve?
Mm. How do we balance that need for stability with justice for new political realities?
And what role might those unilateral declarations play in this shifting landscape? Something to keep thinking about.